Yep, that's great. Thanks.
Thank you.
Hey, Cody, how are you? Good, sir. My name's not Mr. Bowie. Please don't address me like that.
Do you need help, please, sir?
I'm just gonna set it right here. Okay.
Can I set my Brucey up here?
Yeah, go ahead. Go ahead, son. All right. I'm no longer in the police vehicle.
I saw a good
I am
cop. A good
now at the courthouse.
See?
It's just not that one.
You see any of my hair? See any? Daddy, see any of my hair?
Mm-hmm.
I do have hair.
It looks good too, son.
Yep.
Well,
Whew.
I saw it with a deadly weapon,
Jelly.
terroristic threatening,
Jelly.
theft of property, and about three more charges.
It wasn't stealing property. But they did. They did. I don't know why cops steal. I don't know why. They're probably moonlight cops.
Brady, you gotta be quiet. You can't talk, okay? That's all right. You have to be quiet, okay, son? That would help out a whole lot. Sorry, come on, son. Sorry for the inconvenience, Your Honor.
There's a patient.
I was.
Patient as we can be.
Yeah, I was illegally detained and had my private transportation stolen from me and assaulted by a police officer with a deadly weapon and just a number of different things. But luckily, I did record everything on video, so.
That's all very nice.
Yep, very nice.
Sir, we're scheduled for a jury trial tomorrow. You have requested to represent yourself.
It's actually on the 6th, Your Honor. Tomorrow's the 5th.
No, sir, I think it's tomorrow.
Tomorrow we have
According to the notice sheet dated February 20, 2018, tomorrow is the date set for jury trial in this case.
6/5/18 at 8:45 a.m.
Yes, sir. Today is the 4th.
Oh, okay. I'm sorry. I was in reverse there. I apologize. I have a Got to get all this set up right here.
Okay, well, the reason I had you summoned to be here is because I want to explain to you thoroughly, as completely and as thoroughly as I possibly can, the fact that you have the right to have an attorney represent you. Do you still insist on going forward to trial tomorrow and representing yourself without the assistance of a licensed attorney?
Yes, Your Honor, I sure do. It's my understanding that we're going to start tomorrow with jury selection.
Yes, sir.
Yeah.
Do you understand, sir, that you have an absolute right to an attorney if you cannot afford one, that I would appoint one to either represent you, or if you desire one that would be on standby to assist you and answer questions?
Now, I have been trying to find co-counsel, and just haven't been able to find anybody that would do it pro bono.
Do you understand, sir, that well, first off, you really haven't answered my question. You gave me a statement, but do you understand, sir, that you have an absolute right to have an attorney appointed to represent you?
Yes, Your Honor, I do understand that right.
And you understand, sir, that attorney could do one of a number of things. He could represent you entirely and present your entire case on your behalf. He could assist you, or he could be there just to answer your questions. Understand that, sir?
Yes, I haven't been able to find a lawyer that would do that, and I do understand that.
Well,
Yes.
First off, your statement earlier that you were not able to find one that would do it pro bono, which means
For free.
For free, you have the right to have a public defender represent you, and that public defender would not charge you. You understand that, sir?
I understand that, but the public defender is a member of the bar and also a officer of the court.
And you understand that any attorney who represents you is also a member of the bar and an officer of the court.
Yes, that's why I don't want anyone representing me. Like I said, I have been searching for co-counsel.
Well, then you understand, with regard to that, when you say co-counsel, you understand, sir, that I could not allow you to have a friend to come in here and help you or represent you unless that person was a licensed attorney.
Right.
Okay, as long as you understand. I have a case here in front of me which gives me some guidelines as to what I need to tell you and what I need to make sure that you understand concerning your rights. So it may seem like I'm skipping around, but I'm following this guideline because it has been approved by the Arkansas Supreme Court.
What set of laws are we operating under?
Well, this is a decision of the Supreme Court in Williams versus State. It's actually a Court of Appeals case, 2009 Arkansas Appellate Court 684, 2009 case. With regard to any laws that we are proceeding under, it would be the laws of the state of Arkansas as well as the constitutional rights that you have that are set forth in the Bill of Rights to the United States Constitution.
Yes, Your Honor, and that is going to be half of what I base my defense on. I was not allowed due process.
That is a legal argument. That is not an argument to present to a jury, sir. Do you understand, sir?
Yes.
That hang on just a minute, let me finish. You understand that if you are not an attorney and are not trained in the practice of law, that by representing yourself, you put yourself at a severe disadvantage.
Your Honor, I do understand that, and by gaining a lawyer would be more than likely more susceptible to waive my rights and sell my rights.
All I'm asking you, sir, is yes or no questions at this point.
Yes, Your Honor. I answered yes.
Try to answer yes or no, because we get to this much more quickly.
All right. May I? Will I be able to ask you a couple of questions after we're finished?
You might be able to ask me questions, but I might not be able to answer them because I'm not allowed to assist you. I will not be able to tell you when you say, how do I do this, Judge, or what do I need to do next?
No, it's nothing like that. It's nothing like that.
And is it something you want to ask me on the record?
Yes.
Okay, well, why not ask me right now?
Okay. Well, I would like to know if I am presumed innocent until, if I'm proved. Sorry, I'm getting a little tongue twisted here. Presumed innocent.
I can answer that question. I can anticipate it. The jury will be given an instruction that says you're presumed to be innocent, and that presumption attends and protects you throughout every stage of the trial until such time as the jury is convinced beyond a reasonable doubt that you are guilty.
All right. I filed some motions, and all of the motions were not heard or were not responded to. And I've asked a couple of times. I'm not exactly sure as to what type of court this is, or what laws that you guys operate under in this quorum. I filed a quo warranto to find that out, a motion for a quo warranto, and I haven't received any response on that. I have also, one second. I'm not trying to take up all your time, sorry. There we go. Yeah, I filed a writ of quo warranto.
If I recall, sir, if that is the motion that I read, I tried to figure out exactly what you were requesting. I did look at some of the cases that you cited, and it seems that the courts have decided almost unanimously, if not unanimously, that the cases, that the propositions for which you cited those cases stand for the very opposite of what you cited them for. This court operates under the power invested in it by the Constitution of the state of Arkansas. And we apply the law of the state of Arkansas, and we also keep in mind your constitutional rights as set forth in the United States Constitution, particularly the Bill of Rights.
Okay, so I am protected by the Constitution, the amendments 1 through 14, and the Bill of Rights?
You are protected to the extent that you cannot be required to testify against yourself. You are protected to the extent that you have the right to assistance of counsel. And I'm not sure about the presumption of innocence, but that is a long-standing criminal principle that applies in this case, whether it's in the Bill of Rights or not. You are presumed to be innocent until you are proven guilty.
All right, and the proceedings and motions and subpoenas are supposed to be done in a timely manner. Is this correct?
Yes, sir.
What would a timely manner consist of? Maybe in days, if you could answer.
I believe that subpoenas are supposed to be served more than 3 days prior to the date of any hearing or trial, unless the court shortens the time frame for the issuance of subpoenas.
Okay, did the court shorten the time for the issuance of the subpoenas on this? The two subpoenas that I was served with, the one for Julia Bowie and the one for Thomas Bowie?
You were served, you talking about for today's day?
Yes.
You were served with a summons, sir, not a subpoena.
This says subpoena on it. I was served, it says to Julia Bowie, 1338 McPherson Valley, Mableville, Arkansas, 72103, but that's not who was served. It was given to me and served to me.
Well, if you were ordered to be here today.
I have video
sir,
proof.
If you were ordered to be here today, it's so that I can protect your rights. And that is the reason you're here.
Absolutely, and that's,
If I might, may I continue?
yes, sir.
You understand, sir, that as this judge told a defendant in this case that I cited previously, when a person in your situation chooses to represent himself, it never works out right. It always seems to go to the disadvantage of the defendant. Can you understand that that is very likely to happen in your case, sir?
I am aware of that, and I am aware of the maximum sentencing, and I'm also aware I received a letter of some new charges that were brought up just a couple of days ago.
Yes, sir.
Is there not a statute of limitations on how long you can wait to charge someone?
Not on amending an information, sir, and it's my understanding that the information was not amended to add a new charge, but to allege that you are an habitual offender, and all that does is lengthen the range of sentence from 0 to 6 years to 0 to 12 years. And since you brought it up, I do want to make sure that you understand that the sentence that you are facing is 0 to 12 years, or a fine of up to $10,000, or a combination
Of both.
prison time and a fine.
Yes, I'm aware of that.
Understand, sir, that if you were to, let's just say, for example, if you were to receive a 6-year sentence, you would be incarcerated for 1 year before you would be eligible for parole.
Right, before my transfer eligibility date.
That's right. If you were
Yes.
to receive the maximum, which would be 12 years, then you would serve a 2-year prison sentence before you would be eligible for parole. You understand that?
Yes, Your Honor, I do. If the charges that were brought against me previously, and I was coerced and threatened into pleading guilty to, I was charged twice with both of the exact same crimes on both of the exact docket numbers.
Are you talking about
The possession charge?
the felony under which you were convicted?
Yes. In 2006 and in 2009, I was convicted with the exact same crimes.
We're not talking about this trial. That
No,
doesn't-
no, I haven't got to the question yet.
Okay, well, that doesn't have anything to do with this case.
Then why are we allowing it into evidence?
Your argument that you were what I meant was your argument that you were coerced into pleading guilty does not have anything to do with this case. Of course, the state, in order to prove that you were a felon in the possession of a firearm, will have to prove that you're a felon. It would be impossible to prove that you were a felon in possession of a firearm without bringing up your prior felony. And
Okay, well,
let me finish.
all right. I'd like to finish too.
With regard to the number of felonies, that may not come up until you, unless you are found guilty and face sentencing. But the state will have to prove that you have been convicted of at least one prior felony before the state can prove that you were a felon in possession of a firearm.
Absolutely. Now to continue on with my question, if I'll just start over. If the evidence that's submitted is under litigation in another court for a recourse, will it still be admissible in court?
Yes.
Because I was charged 2 times for the exact same crime on the same docket number, and I was threatened with a 20-year sentence instead of the maximum of 3-year sentence.
Yes, sir. If you have convictions, they can be used against you regardless of whether they're on appeal or whether or not you are attacking them collaterally.
All right. Is it safe to say that the state of Arkansas just has it out for me?
Well,
Considering
I'm assuming
they-
that's a rhetorical question that you really don't expect an answer for.
Absolutely.
Because
But-
I do not have any idea if the state has some ulterior motive for charging you. All I know is that you are charged with being a felon in possession of a firearm, and if the state finds that you are guilty, a jury can give you the sentence that I described earlier.
All right.
Do you understand, sir, that if you represent yourself, you have a right to cross-examine witnesses?
Yes, Your Honor. I'm not aware that there's any witnesses besides the state of Arkansas, Mr. or Mrs. State of Arkansas. I'm not exactly sure who to address on that, who will be testifying.
Well, if you have not filed a motion for a discovery, then you probably have not been provided with the names of the witnesses. Mr. Clary,
I have.
at this point.
I filed a motion of discovery, but I am receiving it still in pieces. There was an apology from Mr. Clary for not including all of the motion of discovery, as well as they're still missing the video evidence from the officers at the Saline County Sheriff's Department.
Well,
And that is a detrimental to my defense, because the officer was acting outside of the color of law.
okay, well, let me say that everything that you say is being taken down by the court reporter. I do not want you to say something that would incriminate you.
Right, and I'm not going to do that.
Okay. Do you understand, sir, that you have, if you do cross-examine witnesses, you have to know how to do it?
Yes, Your Honor.
You understand, really, essentially, you have to know the same things that an attorney would know.
Yes, Your Honor, and I have been studying Uniform Commercial Code for a little over 9 years now.
Well, I'm not certain Uniform Commercial Code would assist you in this. You need to know the rules of evidence, the rules of criminal procedure. You need to know the proper way to phrase questions on cross-examination. If you call witnesses in your own defense, you have to know how to conduct a direct examination. If you have jury instructions that you want to consider giving to the jury, then you have to know how to prepare those instructions. If I decline to give an instruction, you have to know what to do if I decline it. If you want to preserve a record on appeal, you have to know how to formulate a defense and present that defense to the jury. You understand that, sir?
Yes, Your Honor, I understand that. I did receive notification from Mr. Clary here of the instructions to the jurist that will be given, that you, as I assume, have accepted.
I have not looked at them, and I will not look at them until tomorrow.
Okay, okay.
Do you understand, sir, that if you represent yourself and it turns out to be a total disaster and you get
I will not be eligible for a retrial.
well, you understand that you cannot complain about ineffective assistance of counsel if you represent yourself and do it for me.
Right, and I will be my best defense. I'm in the interest of myself and not a monopoly or extortion. Your Honor, may I ask you a question?
Let me finish these and then you can ask.
Oh, okay, sure.
questions.
Sure thing.
objections, if you had an objection to something that the state wanted to put in?
Yes, Your Honor. Such as an objection, cause for speculation, things of that matter.
Yes, sir.
All right. Or
And you'll
maybe.
but if you make an objection, you will have to articulate the reason for your objection.
Right. Exactly. Just like if I was to object for a legal conclusion, I would have to explain why there would be a legal conclusion. I understand this.
If you made an objection and said that question calls for a legal conclusion, then that would be enough argument, sir, for you to make.
Absolutely.
You know, even attorneys who represent themselves have a great difficulty doing that. You understand that, sir?
Yes, Your Honor, I understand that completely, and I'm fully and willingly accepting responsibility for representing myself in court. I plan on having a very large counter injunction, if you would like to call it that. Are there any witness statements from Mr. and Mrs. State of Arkansas on record?
Well, I don't know, that must not be a question for Mr. Clary.
Okay, Mr. Clary, are there any witness statements for Mr. or Mrs. State of Arkansas on record or in the injunction?
Judge, I'm unfamiliar with the injunction that Mr. Bowie is referring to. I provided him a copy of discovery. There are no statements by the state of Arkansas, but there are incident reports reviewed by the deputies. There's a statement by individuals. They're also at the scene.
If you ask a question and the state objects, and you do not give me a good reason for allowing you to ask the question and have an answer, then I'm going to sustain the state's objection.
Yes, Your Honor, I understand that.
I want to say one other thing. And the defendant responded, and he recognized this. He said, essentially, that the person who represents himself has a fool for an attorney and an idiot for a client.
Are
Have you
you?
ever heard that before?
Oh, okay. I thought you were calling me an idiot and a fool. No, you said, have you ever heard that?
No. It is sort of a, I don't know what the right word would be, sir, but it is something that has been said for ages and ages. It's not, I'm not calling you a fool, I'm not calling you an idiot. I'm just saying that there is a saying, and this defendant in this case acknowledged that saying, and actually it was surprising that he acknowledged that when the judge asked him if he really clearly understood the purpose of representing himself. This defendant merely said, yes, I understand that a person who represents himself has a fool for an attorney, and an idiot for a client. So that's what this defendant said when he was asked that question. Do you have any questions that you want to ask me? Any other questions that I might be able to answer?
Well, yes, I do. I have read through all of the motions that Mr. Clary here, and I believe it was Mr. Cassidy also has sent some other documentation over to me. You know, as I previously said, that I wasn't I wasn't able to hear a proceeding on this motion to strike or dismiss complaint request and full findings of fact and conclusions of law, and the quo warrant tow. But as you stated before, the quo warrant tow was not properly filled out. So, but it was just really I wanted to know, so. Did you sign an oath to office?
I'm sorry.
Have you, as a judge, signed an oath to office?
Yes, sir.
You have, and
I have taken an oath of office. I'm not sure that I have signed an oath of office, but I do that. Yes, sir. I have taken an oath of office.
okay. And the bond of the judge and attorney, as required by state law, is that in effect? Have you guys, have you made a bond of judge and attorney as required by state law?
Well, I don't know of any state law that requires me to post a bond in order to be a judge.
It's part of the quo warranto. Anyways, we'll move on.
Well, you would have to show me something within the Arkansas Constitution or within the statutes.
Well, I have the Arkansas Constitution here. Let me see if I can find where I highlighted that. There we go. Code of Judicial Conduct. Here, rules. I'm sorry, one moment. It's right here. Questionnaires. I believe it was in Rule 602, but I cannot swear to an affidavit of truth on that.
Well, are you talking about the rules of evidence?
No. State of Arkansas, the state law, the annotated code requires there's got to be a certificate of good standing as an attorney, a copy of license of attorney, authorization granted by the Supreme Court, of which that certifies which should be kept in the office of the clerk of court of the state of Arkansas in the Supreme Court per law, and as to information from the plaintiff. I had requested information that I wanted so that I could file some injunctions against the company.
Well, sir,
I need the-
I have a certificate on the wall in my office that shows that I have been appointed, not appointed, but elected to the office of circuit judge for this term.
All right. Let's see here. It is Article of Incorporation, Article of Association, Application Form 1023, or Application Form 1024 for nonprofit status, tax exempt. I need the plaintiff's legal title name, EIN, completed W-4, the IRS determined letter for the municipal corporation you are claiming to represent. The state of Arkansas EIN, just as it is on paperwork, as well as a copy of the license to do business under an assumed name, and the IRS determination letter, article of incorporation, article of association.
Consider that to be a motion, signed, denied.
You said motion denied? All right, I have another motion. Motion to strike and dismiss complaint and request of full findings of fact and conclusions of law. It now comes before the 22nd District Court. Benton, Arkansas, Saline County. Tommy, the only known authorized representative of the commercial entity account for Thomas Bowie, which is not all capital. Alleged defendant, by special appearance today, participating under threat, duress, and coercion, not submitting to the court's jurisdiction, who hereby moves this court to strike or dismiss the complaint filed by Saline County Sheriff's Department for failure to present cause of action or crime. Failure to present course of action deprives the court of jurisdiction. Grounds are further set forth below. The court is further requested to provide full findings of facts and conclusions of law if the court denies this motion. Just saying it does not apply is not sufficient grounds to deny this motion because some courts refuse to disclose the nature of the proceedings. This motion covers both civil and criminal. If deemed to be civil, the criminal parts may be ignored and vice versa. No case, crime, or cause of action. The foundation for the court's jurisdiction is the purpose of American government itself. This is in the Declaration of Independence of 1776. I can recite that. It says, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed." Now, this application to the Arkansas governments through the act of the State of Arkansas Enabling Act, this is also shown in several other state constitutions regarding the establishment of American governments. Governments are established to protect and maintain individuals' rights. You can see Arizona, Washington, and Minnesota. Would you like for me to recite the case law? I mean,
No,
that would be pretty. Yeah. Okay.
Motion that is being.
Well, this is. I'm sorry, Your Honor, I haven't finished. This is why we have a case or cause of action. A plaintiff must plead the violation of a legal right. I have not made a plea of not guilty in this quorum. A plaintiff must show the injury to himself caused by the defendant, the injury having a remedy in the law or equity. The injury need not be either large or economic, but it must be palatable. Worth 422 U.S. at 498. Finally, plaintiff's injury cannot be merely speculative. A bare allegation that plaintiff fears that some injury will or may occur is insufficient. Confer standing. Los Angeles versus Lycus, 1983. There's many of those in here. The basic elements of a case or cause of action are the violation of a legal right and loss or harm. The alleged plaintiff, a legal fictitious at best, ostensibly acting throughout plaintiff's state of Arkansas, has not pled any violation of a legal right or harm. Legally, there is no cause of action. A cause of action, of course, is some particular legal right of plaintiff against defendant, together with some definite violation thereof where occasions loss or damage. That's Lucky versus Macau Manufacturing Company. A lot of case law there. This includes proceedings like this, these allegedly criminal in nature. Causation consists of two distinct supplements, as legal scholars have recognized. Before a defendant can be convicted of a crime that includes an element of causation, the state must prove beyond a reasonable doubt that the defendant's conduct was the cause in fact, and two, the legal cause, often called proximate cause, of the relevant harm. In order to establish that a defendant's conduct was the cause and effect of a particular harm, the state usually must demonstrate that before the defendant's conduct, the harm would not have occurred. It is fundamentally principle of law that no person be adjudged guilty of a crime until the state has shown that a crime has been committed. The state therefore must show that a harm has been suffered of the type contemplated by the charges, for example, a death in the case of a murder charge or loss of property in the case of a theft charge, and that such harm was incurred due to criminal agency of another. Thus, it is sufficient if the elements of the underlying crime are proven rather than those of particular degree or variation of the crime which may be charged. Even if the absurd claim is made, harm is not a necessary element of real crime. The complaint is still fatally flawed, and there is no accusation alleged defendant violated anyone's legal rights. If there were true adversary against alleged defendant, it would be laughable to even discuss causation, because defendant is not accused of causing anything real or imagined. No corpus delicti. The corpus delicti, of course, is the body of the crime itself. Virtually every American jurisdiction agrees it's an absolute essential element of any crime, and it is consistent with the stated purpose of the American government. I have many, many case laws here, and I'm sure that you don't want to hear that. The term corpus delicti embraces occurrence of loss or injury and criminal causations thereof. State versus Hill, New Jersey. It has long been fundamental to the criminal jurisprudence of the Commonwealth that a necessary predicate to any conviction if proof of the corpus delicti, i.e. the occurrence of any injury or loss of someone's criminality as the source of the injury or loss. You can see Commonwealth versus Burns, so forth and so on. Lacking of jurisdiction. Standings represent a jurisdictional requirement which remains open to review at all stages of the litigation. I'm aware of this. Without a cause of action, legal injury pled, there is no jurisdiction. Although the Arkansas Constitution contains no case or controversy requirement, the federal limits on justability are instructing because the standing requirements under both federal and state constitutional laws fulfills the same purpose, ensuring that the litigant is entitled to have the court decide the merits of the dispute or the particular issues. ID at 1044. Under the federal test, to establish standing, a plaintiff must allege a personal injury that is fairly traceable to the defendant's allegedly unlawful conduct and is likely to be redressed by the requested itself. I'd citing Allen versus Wright, 768 U.S. 737. Many more case laws on that. Under the general rule of standing, only those persons who have a personal stake in the outcome